stare decisis, which of course is the legal principle. If we're engaged in active restoration, what are we permitted to restore? So we have to address, as best I can work it out, stare decisis, the principle that courts must be bound by previous decisions. Two quotations. Here's legal. I've already read you the quotation from Daniel Frost that even Justice Warren's admirers are not entirely certain the Constitution authorized him to produce some of the decisions he produced. Here's retired Supreme Court Justice Stephen Breyer. Stare decisis does not exist simply to protect precedent that is right. It keeps the law stable by preventing the continuous re-examination of precedent that may well be wrong. The fact that judges think an earlier case was incorrectly decided cannot be, and never has been, a strong basis by itself for overruling an earlier case, close quote, which of course reminds me of the old saying by G.K. Chesterton that it's the job of progressives to make mistakes and the job of conservatives to prevent them from being corrected. When does this court feel bound by precedent, even if it may have some notion that the precedent was incorrectly decided? And when does it come to the conclusion, when may it properly come to the conclusion that a decision was so incorrect that the court must overturn it?
Well, there's a variety of thinking on the question among the members of the court now and in past years. Justice Thomas is most willing, of all the justices, most willing to reconsider past precedents. If he thinks a past precedent is clearly wrong, he is more open to re-examining it than, let's say, even Justice Scalia. When Justice Scalia was on the court, he was certainly in favor of re-examining egregious decisions under appropriate circumstances, but he did not think that it would be workable. I don't think I'm putting words in his mouth. I don't think he believed it would be workable for us to reconsider every past decision that figures in a case that comes before us.
Right. So I once interviewed Justice Scalia, and he brought up Marbury versus Madison. He said, suppose we're hearing a case and the justice says, now, counsel, why do we have the right to even consider whether we should overturn this?
Do you think we have the power to ignore a statute enacted by Congress simply because, in our view, it's unconstitutional? He says, oh, yes, Your Honor, Marbury versus Madison. I know, Mark, but was it right? Let's rethink that. You can't run a legal system that way, reinvent the wheel every time you have a new case.
All right, so that
is what he thought, and it really brings to mind something that occurred during an oral argument in a case called McDonald, which had to do with whether the Second Amendment right to keep and bear arms applies to the states, and in that case to the city of Chicago. Without getting into the technicalities, whether or not it applied depended on an interpretation of the 14th Amendment. And there are two provisions of the 14th Amendment that could govern. One is the Due Process Clause, which is the way the court has analyzed this issue for more than 100 years, well more than 100 years. And the other is the Privileges and Immunities Clause. And a lot of scholars think the Due Process Clause was the wrong path. It should have been the Privileges and Immunities Clause. And in this case, that's what the lawyer for Mr. McDonald, who wanted to have the gun, was arguing. And that position was supported by groups across the ideological spectrum, including libertarians on the one hand and progressives on the other. And we got a brief from some law professors who said, we look forward to the day when we can tell our students that the Supreme Court has corrected its mistake. So the lawyers started to make this argument, and Nino cut him off, and he said, that argument is the darling of the professoriate, but you have 100 years of precedent, so get on to the rest of the argument. And it was very telling because Nino was such a professor, I think, in his heart through his entire career. But he recognized that deciding cases is different from writing law review articles.